Well, to discuss the Zimmerman trial further, Elisabeth Pasqualini, a criminal defense attorney from Shaffer Engle law firm, joins us now live with expert analysis of the proceedings so far. Thank you for joining us.
Well,
thank you for having me.
You've been in courtrooms in front of juries. The jury got this case tonight. They resume tomorrow morning at 9. How soon do you expect a verdict?
I don't expect a verdict anytime soon. There are 6 women who are sitting on that jury. They are going to take their time and they're going to look at the evidence and they are going to talk about it. They asked for the list of all of the evidence.
All right. Well, we want to get into this somewhat, some people are calling a backdoor charge that the prosecution added in at the last moment. Zimmerman went to trial for second-degree murder, but now the jury is being asked to consider a manslaughter charge as well. What's the reasoning behind this?
In Florida, similar to Pennsylvania, either side can ask for what's known, again, like a drop count. Okay. If the prosecution doesn't think that they have proven their case, they might, as a backup plan, say, well, gee, we'll take the manslaughter if you're not willing to convict on second degree. Right. So they do it as a compromise verdict.
Now, what's the difference? I mean, what's the sentencing difference? The jury doesn't know the sentence on either one. Is that correct?
They should not know. It's generally the jury's job to figure out what the facts are and not to be concerned with what the punishments are. So if Mr. Zimmerman is convicted of the second-degree murder, he's looking at a minimum mandatory sentence of 25 years to life. Okay. Should he be convicted of the manslaughter charge, he's looking at 9 3/4 years up to about 30 years.
Okay, Mark O'Mara, the defense attorney today, brought in a bunch of props. He had a big piece of concrete at one point, some cardboard cutouts, and at another point, he wanted to point out the time that Zimmerman hung up the phone between the time Rachel Gentile says Trayvon Martin's phone went dead. That was 4 minutes. So what he did was he had the jury sit in silence. Let's take a look at that.
4 minutes. That felt like a long time to you before we took the break, that we sat here and did nothing for 4 minutes? You get to think what Trayvon Martin was doing.
Interesting tactic there, because they sat there in kind of an awkward silence for 4 whole minutes.
It got their attention and it got yours, didn't it?
It did.
Made you think.
And that's what, obviously, the defense wanted to do there.
Absolutely. And this is a long trial. This is 3 weeks. It's, even though it's very important, it's hard to keep people's attention and keep them focused. And you've got to sometimes go outside of what you normally would say to, just in a discussion to make people think and focus and to put themselves right in the moment.
You could feel the tension in that courtroom today. The mood's so much different than yesterday and during testimony. Here's John Guy, the defense attorney, with a totally different tone than he had brought to the trial before.
If it was Trayvon Martin who had shot and killed George Zimmerman, what would your verdict be? That's how you know it's not about race.
Now, he's the assistant DA. The district attorney during closing arguments was very forward, very loud, very in your face, and even the defense attorney noted that in his closing that, hey, you're going to hear from the prosecutors again, they're going to be in your face. But he came out very calm and very quiet almost. What was the tactic there, and do you think, in your opinion?
Oftentimes, if the other side's going to say the other lawyer is going to do this, tactically, you probably want to not do what the other lawyer just said you're going to do. So it was effective.
He might have shifted gears right there.
Oh, absolutely. And if the other attorney had said, oh, he's going to come out and be quiet and you know, boo-hoo, and he'd have been probably quite loud and boisterous and did the exact opposite of what they said he was going to be.
Well, I was riveted on the whole thing. I watched O'Mara. You felt that Zimmerman was probably not guilty. And then you watched Guy and you thought, well, he is guilty. That means they did their job right.
That's right. You know, both sides did a very good job of presenting their arguments. With regard to Mr. Guy, he's no dummy. He knows he's got 5 mothers sitting on his jury, and he said more times than not, he kept calling Trayvon Martin a child. Yeah, that child. Imagine your child's worst fear. And yeah, he was playing to his crowd.
Well, the defense brought out those cardboard cutouts of Trayvon Martin versus George Zimmerman because in a lot of folks' mind, they think of Trayvon Martin as a child because we keep hearing that word, but in fact, Trayvon was much bigger in the cardboard cutouts. Do you think that was a good tactic to pull out?
I think it's certainly important. If the other person isn't there, you're left with only visuals. There was very little physical evidence here. There's only one guy still alive who was there to say what happened. So if you can get a perspective about who's big and who's little, sometimes a visual aid is much better for you than just to hear it.
And then John Guy brilliantly brought it up in his close. They call him the closer. He said Trayvon Martin never will be, never was a cardboard cutout. Kind of turned it around on Mark O'Mara.
Okay, a criminal defense attorney, what are you doing right now? What's going through your mind? What are you telling your client at this point?
Yeah, how do you deal with the emotion there?
It's incredibly trying. I mean, on one sense, you're happy that just the trial itself has concluded, and you're hopeful for a verdict. You try to keep your client calm. You try to make sure that you've done everything that you need to do. If there's juries are going to come back with questions, you have to sort of maybe anticipate if you think there might have been questions and be ready to answer those. But yeah, it's tough.
You just have to be on a hair trigger. I mean, you're just waiting for any kind of word to come from inside the courtroom.
Yeah.
And then, I guess when questions come, your client, that gets even more nerve-wracking.
Right.
Oh, absolutely, because one of the first ones is always, what is reasonable doubt?
Right.
Juries, and I don't mean to be flip, but they come back with that 5 out of 6 times. They will have what is reasonable doubt, because it's such a fluid concept. Yeah, and it's incredibly nerve-wracking, and just to sit there waiting for the phone to ring.
All right. Elisabeth Pasqualini, thank you so much, with the law firm Shaffer Engle, joining us with expert analysis. We appreciate it. It's so good to get the inside.
And to compare it to Pennsylvania law and everything, we really appreciate the time.
Sure.
Thank you.
Thank you both.
Thank you.